And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning and welcome to The Law Show here on CIL 650. With that introduction from Sister Sledge, we are family and we are going to talk about family law for the next hour. Nice to have you with us today. We have a couple of guests in studio from Westside Family Law on West Broadway in Vancouver. Founding partner Mark Perry is back with us. Good morning, Mark.
Good morning.
Nice to see you again.
Nice to see you too.
And Jill Chapin joins us for the first time. Hi, Jill.
Hi.
You are one of the new members of the team at Westside. You're from Saskatchewan originally. What caused you to pick family law out of all the possibilities when you were in law school? Why on earth did you settle on family law?
It actually wasn't what I thought I would be doing in law school, but when I became a litigator, I was able to practice in a variety of different areas.
Okay.
And I really liked the aspects of problem solving and client contact relating to family law. It was an area that fit well with my personality, and yeah.
It was just a match.
It was just a match.
There you go. Mark, we've talked about your career in the business for close to 30 years.
Absolutely, yes.
And highly regarded litigator and mediator. What's the difference between those two activities?
Well, litigator is basically appearing in front of a judge,
okay,
and arguing on behalf of a client how an issue should be resolved. Mediation is sort of, if you like, almost being the judge.
Okay.
Although you're not deciding an issue, you're facilitating people coming up with a resolution. So you're negotiating with people. You're helping them negotiate a resolution.
Right, and Jill, you were talking about some experience you have as a litigator as well. In family law, we're talking about divorce and the breakup of relationships and so on. Ultimately, how does it come down to in terms of the break between litigation, cases and situations that end up in court versus those that are mediated or dealt with in some other way? I would assume the preponderance, the majority, would be not in court, or am I wrong?
Yes, court's sort of the last resort.
Okay.
If you absolutely can't negotiate, you can't agree, then you have to have a neutral third party decide.
Right.
That's actually, I mean, I don't mind litigating, but it's an unfortunate result for people in a lot of cases. So we try everything before court. And then if that doesn't work, we litigate it out.
Right. But Mark, the idea, I would assume, at least, obviously you both go to court, and so if necessary, off you go. But ideally, it would be more to everyone's advantage not to go to court.
Oh,
would
absolutely.
It?
Absolutely. Most judges will say to parties, as part of the court process,
right,
so they'll say, you do not want me as a judge to decide these issues. You would rather, you should rather work out your own arrangement. Because a judge's decision may not be something either party wants.
Exactly.
It
right.
may be something down the middle that's not workable.
Yeah.
And, that's just the nature of a judge deciding this. So for parties to negotiate and come up with their own solutions is always better.
Right, and that's the risk, Jill, that you just referred to earlier. If you leave it ultimately in the hands of a professional, a judge, that person is going to make a decision based on whatever facts are presented. And as Mark said, it's quite possible that nobody's going to be happy, or it's also possible that somebody is really going to lose big time, right?
Also true, yeah.
Okay. So how do you, if you're confronted by a client, Jill, who comes into the office and it's over, and it's not over happily, and in fact there's a fair bit of hostility and aggression and anger, and this person sits down in your office and they want you to strap on your six-shooter and take that guy into court and just and punish him. How do you deal with that kind of intense emotion? And I'm sure you deal with it pretty frequently.
Yeah, I mean, sometimes people come in and they're really intent on going to court and getting a certain result. Obviously, I'm going to outline all of their options, the pros and cons, because ultimately it's just about weighing things logically. At the end of the day, I am going to act according to the client's instructions. You know, if they want me to do it, that's their choice,
Right.
and it's their right to make that choice. But I'm going to let them know what all the choices are.
Right. And Mark, that's part of it. And you and I have discussed this in the
Yes.
past as well. Obviously, if the client wants you to do that, then that's what you'll do. But it's not really what you'd prefer to do,
Right.
and it's not what you might even view as being the best circumstance for that client.
Right. Well, those two things, what I prefer and what are the best circumstances for that client, they're connected.
Right.
What I prefer is the best outcome for the client.
That's true.
Sure.
Right?
Mhm.
It's not my personal preference, because I want to be clear. I love being in court.
Okay.
Also true.
Okay.
There is nothing like the adrenaline rush of being in front of a judge arguing a case.
I believe that.
But it's not what I want. What I want is what's best for the client.
Right.
So I will perceive that, yes, that client is speaking about wanting to end up at a trial and being in front of a judge, and I will know that that's not necessarily best for that client.
Right.
I will take their instructions, but I will be spending time over a long period of time before you end up in front of a judge, perhaps outlining again the different options. And
Right.
hopefully calming the client down, and then getting reasonable instructions.
Well,
to
and
resolve.
I suppose the advantage that you have as lawyers, Jill, is the fact that this doesn't have to happen on day one. Somebody comes into the office just all steaming hot, mad, and ready for World War III. Well, nothing's going to happen that day anyway. And so by way of sort of presenting a series of options for your consideration, one of which may have me trotting off to court on your behalf, but let's just take a moment and have a look, right?
Yes. Well, and the bad news for people who think that they get their day in court really quickly is that it doesn't work like that. There are many steps where you're looking at, 9 months from now, a year from now. And for a lot of people, that time is also a something that they're not willing to spend. Do you want to have this fight for 12 months?
Right, right.
Yeah.
Okay. Wanted to spend a lot of time on the program today talking about spousal support. This was the notion that was brought to the program by Jill and Mark. And so I think if we're going to talk about spousal support, and there are a lot of myths surrounding this, but even before we get to the mythology involved and then the facts as well, what's the difference when you go into a family law scenario and there are payments to be involved, and we're talking about spousal support? Does spousal support, is that an all-encompassing phrase that covers kids and mortgages and accommodations? Break it down for us, Mark, if you
Sure,
can. What does
absolutely.
spousal support really mean in law?
Okay, well, you've raised a couple of ideas that it could include, and it does not.
Okay.
It does not include child support. Spousal support is monies paid by one spouse to the other spouse.
Okay.
Okay. It most definitely does not include child support. Child support is based on number of children, where the children reside, and spousal support is separate.
But you would at least acknowledge that it's a fairly common mistake that we make,
Absolutely.
was
Yeah.
sort of lumping everything together under one general support column.
That's
and
right.
so now we need to learn that that's not the case.
That's correct. Absolutely correct. And spousal support arises at the end of a relationship where there is a significant or difference in the incomes of both spouses.
Right.
And some of the circumstances during the relationship has led to one spouse not being able to earn as much as the other spouse. That's when there's going to be spousal support.
Okay. And who determines spousal support, Jill? Is it something that in the mediation process somebody makes an offer and the other person says, not a chance, and it gets negotiated? Is there a formula? How does it go? How does it work?
Well, there's actually, in some cases, there's quite a bit of flexibility with spousal support. A lot of people don't realize that there are different options. Some of those options have different tax implications. But we start with something called the Spousal Support Advisory Guidelines, which are kind of it's a tool that has been used by lawyers and judges to apply a variety of facts to an algorithm, and it gives you kind of a starting point for the conversation.
Okay.
Mm-hmm.
And so this would be, is this tool commonly available? Can people at least have access to it? So in terms of trying to understand how it might work,
Right.
We can go somewhere and get a clue?
Yes, lawyers use a professional version, usually to do their SSAG calculations, called DivorceMate. The company that produces that actually realized that they needed to make maybe part of that available more freely to the public.
Okay.
And so there is a site called mysupportcalculator.ca, which does a very rough version. Oh, I'm sure DivorceMate will say, "Oh no, you've got this wrong, Jill." But it does a basic version. It's spousal support for beginners, spousal support for lay people who are just really curious about this concept
Okay.
and what might be the starting point.
Okay. And but this would be the simplistic version for lay people, Mark.
Absolutely. Yeah.
Yeah.
The lawyers and the judges use a more sophisticated version of the same thing. So how does it work when you're trying to determine how much spousal support one must pay, or on the other side of that coin, one should receive?
Right.
Tell us how.
Well,
Is there a formula of some kind?
When I speak to clients about this, I talk usually about 3 sub-issues relating to spousal support. The first is entitlement. Is a person entitled to spousal support? And sometimes even with lawyers, I will receive from them a calculation, and they've skipped over the ideas whether there's any entitlement or at all.
Okay, so this would suggest that in some cases, at least, individuals might not be entitled to spousal support.
Absolutely.
Okay.
Right. So I'll give you an example of that. A case I had not too long ago, maybe about a year and a bit.
Okay.
A huge difference in the incomes of the 2 people. I'm trying to be gender neutral here.
Okay.
But a 2-year relationship. Okay, 2-year relationship, no children.
Okay.
So if you put into the computer software that even we use, it would provide a entitlement and an amount for spousal support, but it's skipped over to some extent the entitlement question. In that case, looking at the case authority and the underlying principles, there really isn't an entitlement to spousal support.
Oh, okay.
All right? It's too short a relationship for there to be spousal support.
Oh, okay. So what typically would be a duration time for a couple to enjoy, I put in quotes, before leaving, and then spousal support kicking in? What would a typical, 5 years, Mark?
Sure.
Okay.
2, maybe more than 2.
Okay.
It would be easier to say.
All right.
Because in other situations, 2 years might be enough time. I mean, it's just far more than simply looking at the difference in the income. There
Right.
are other considerations. So I'll give you an example. I had another case where it was maybe a 2.5, 3-year relationship. A spouse had given up employment and a career in another jurisdiction to come to Vancouver.
Oh, and to be with this person.
To be
right.
with this person.
Right, right. Walked away
relationship-
from a good income and
That's
a
right.
career.
That's
Okay,
right.
all right.
So even though, looking at that adding that one fact, in that case, in the second case, provided entitlement to spousal support.
Okay.
So that's the first issue, is entitlement. And again, people come to lawyers for our experience in applying both the guidelines that Jill spoke about,
Right.
but also the cases. And then just having common sense understanding of the way the law works.
Okay.
The second issue is the amount, or quantum.
Okay.
And that's where the software that Jill's speaking about is brilliant. I mean, it's very, very good. It does provide an amount, and it takes into account the tax consequences. It incorporates child support, because that's a factor that reduces the amount of spousal support if there is child support.
Okay.
The trick there, or the issue that we have with quantum, is determining the incomes, which isn't simple. The incomes of the 2 parties.
Okay.
So we spend time looking at tax returns, considering the law, and looking at the incomes. And then the last issue with spousal support is duration. How long is this support going to last? And again, there are all kinds of rules that we look to in each individual situation to determine what that's going to look like.
Well, it's interesting because we need to take a break, but as you suggest, the fact that there might be a term attached to spousal support. We're going to get into some of the myths surrounding spousal support when we come back.
Right.
And that one that's fairly widely held. I think you're going to open more than a few eyes in just a very couple of seconds here.
Or ears, because we're on the radio.
Well, that's true, but you'd be surprised what the expressions people's faces make when they hear something. And really, I did not know that. Mark Perry and Jill Chapin with us from Westside Family Law at 1367 West Broadway in Vancouver and online at westsidefamilylaw.ca. Lots more ahead here on The Law Show. Stay with us. We're back after this.
There's more of the show still ahead. This is The Law Show on CL 650.